The state and the defense have both finished their closing arguments in the Dima Tower case. Let's talk about that. Here's what we're talking about today. Closing arguments are designed to be a way to refresh the jury's recollection about the facts that they've heard and to put the prosecution and the defense's spin on those facts to illustrate either premeditation in this case or a lack thereof in the defense case. And because the defense has already admitted that he's guilty of something, it's unlikely that the jury would find him not guilty. But oddly enough, during the actual jury instructions, the judge talked about self-defense, which, as far as I could tell, is nowhere in this case. Be that as it may, let's listen to a little bit of the prosecutor's closing argument here.
Good morning, ladies and gentlemen. Back on Monday, which probably seems like an eternity to you by now, the judge talked about the two things that the state has to do in its case. It has to prove beyond a reasonable doubt that a crime or crimes were committed in the murders of Robbie and Jennifer Tower and the fleeing to elude. And that the defendant who sits here in the courtroom before you, Dima Tower, is the person who committed those crimes. I think that those things have been proven to you fully during this trial. The only thing that we should talk about today, and that's important for you to focus on, is the defendant's intention. Because in opening statements, defense counsel told you that he was going to argue for a lesser included crime, a crime of manslaughter. So let's think about the instructions that you have in front of you and what they say and why this is not manslaughter and it's not second-degree murder, and it completely and fully meets all the elements of first-degree premeditated murder.
Now, it's interesting and in some ways a little funny that they've picked the most unflattering picture of the defendant they could find in their files to put up in their closing argument PowerPoint. And then this lawyer couldn't work the PowerPoint, or there was something wrong with the machine, I'm not sure which. So they had to take a short break, and that's what they're doing in this little part of the closings. I find it funny because in some respects, you definitely want to make the guy out to be the guy that he is, but he almost looked like he'd escaped from a prison camp. He was gaunt. I mean, it definitely showed him to be something other than the guy who's sitting at the counsel table. I'm not sure whether that works for or against the prosecution. Maybe you can tell me what you think of that photo and what you think of her delivery.
You've probably worn out that carpet by now, going back and forth, but let's continue where I left off. So what we have to focus on are the instructions, the law, and the evidence in this case. And you have those instructions in front of you, but I have the elements of first-degree murder up on the screen. So to prove the crime of first-degree premeditated murder, the charge that the state has laid against the defendant, actually 2 counts, but I incorporated both Jennifer and Robbie Tower into this instruction. To prove the crime of first-degree murder, the state has to prove the following 3 elements beyond a reasonable doubt. Jennifer and Robbie Tower are dead. There's no question about that. It's uncontested. Their deaths were caused by the criminal acts of Dima Tower. Again, uncontested. Not only do we have all the physical evidence in this case, the knives, the fact that the defendant was covered in blood, the fact that he fled, but we also have his own words. He told the detectives who interviewed him that he killed his parents. So we know that their deaths were caused by Dima Tower, and obviously they were criminal acts because he stabbed them to death. That's a crime. Finally, there was a premeditated killing of Jennifer Tower and Robbie Tower. And how do we know that? We know that because the defendant told us so himself over and over and over. Yesterday afternoon, on the stand, he told you that himself. Repeatedly to the detectives, and then again, right here in the courtroom where you're sitting today.
Now, I suppose it's obligatory for her to go into the actual evidence and show the crime scene photos and the autopsy photos and all of that. I'm going to leave that part of her closing out because you don't need to be burdened with that. It's bad enough that the jury has to see it and then go home and try to sleep tonight. It is amazing to me that we sometimes treat juries rather badly in criminal cases, expecting them to just forget what they've seen. There's no way looking at this could not change you, at least in some small way. So I'm going to go over that part of it, and then I'm going to go to the part where she relinquishes the speaker's lectern to the defense counsel, but she has some closing remarks to make before that point.
Instructions and what you heard on Monday about sympathy. You saw the defendant sobbing here in the courtroom. We had to actually take a break. I think it was on Wednesday during the defense's opening statement. And then again yesterday when the defendant took the stand. He put on quite a display of emotion.
Overruled. Let's move on from this, okay?
He put on quite a display of emotion. Hold him accountable for what he did. You may not have sympathy enter into your deliberations. Your job is to look at the evidence and see if the evidence comports with the law, first-degree murder. You may not have any sympathy for Robbie or Jennifer Tower or the defendant. And that's hard to ask human beings. And you may even have sympathy for all three of those people. But they cannot influence your decision. That cannot influence your decision. You have to compartmentalize that sympathy if you have any. Because the law says that you must judge the defendant on the evidence and the law. Hold him accountable for what he did, ladies and gentlemen. Thank you.
So one of the things that drove me absolutely nuts about this prosecutor is that she'd spend some time at the lectern and then she'd wander over toward her PowerPoint and then she'd wander back. And each time she wanders away from that microphone, obviously the clarity of her speech and the volume of her speech goes way down. So I've tried to fix that by going in and clipping those parts and boosting the volume on it. But of course, that introduces some noise too, so it's a little less clear. But again, if you're going to do this, you should practice beforehand. There are these wireless USB mice that you can use and hold at the lectern and use it to advance your PowerPoint. These are commonplace and you can buy them at Best Buy. You can buy them pretty much at Office Depot. Almost any place that sells computers will have one of these. And then you don't look like you have to wander back and forth to do your closing statement. I think the jury must also understand they might very well have had trouble hearing some of her argument because she kept wandering away from the microphone and talking to her computer instead of talking to the jury. So, at least with the end there, I was able to put together a piece where she was standing at the microphone. Now it was the defense's turn.
Like we talked about at the beginning of this case, Mr. Towers' words still hold true. It has a lot to do with everything that I've been through and everything that I've seen. And you've heard a lot of evidence in this case, and frankly, a lot of it was not disputed. The facts and circumstances of the tragic events of August the 31st of 2023 are not materially in dispute. Robbie Tower is deceased. Jennifer Tower is deceased. Those things occurred because of acts by Dima Tower. That is not in dispute. What is in dispute is whether or not Dima Tower had the rational, conscious intent to commit the homicides prior to them occurring. That is what is in dispute in this case, and that is what we have been asking you to focus on and not get sidetracked into different areas. The judge has instructed you that you have to presume Mr. Tower to be innocent before you start. We kind of dialed that back a little bit and said, look, before we even start this trial, I want to make sure that we're clear about what we're asking of you. And what we're asking of you is to make a decision about one simple thing. And it may not seem that simple, and it may seem very complicated to get inside the head of somebody else. And it is. It's complicated. The state has the burden of proving these crimes beyond and to the exclusion of every reasonable doubt. I know the state will say that most of what we've been talking about is trying to invoke sympathy for Mr. Tower. That is not the case. It is important if you're making a decision about somebody's state of mind that you are exposed to them so that you can make an informed decision. There's a lot of talk in the jury instructions about people of ordinary judgment making decisions. And what the judge has instructed you is that it's up to you to decide what evidence is reliable. You should use your common sense in deciding what is the best evidence and which evidence should be relied on in considering your verdict. We talked during jury selection about the fact that you don't leave your personal life experiences at the door. You bring those in because they form your common sense. And you can make the determination as to whether or not it's significant that Mr. Tower couldn't look me in the eye, couldn't look the state attorney in the eye, couldn't look the detectives in the eye at any point in time. That is something that is common for certain people. And when we're talking about individualized consciousness of guilt, every individual reflects differently. Every individual thinks differently. So if we're talking about the fixed time for reflective thought, it's important to consider all of the factors as to whether or not Mr. Tower had sufficient time for him to make reflective thought. given his history.
So, as you can see, the defense is arguing that it wasn't premeditated and that it relates back to all of the stuff that this guy went through when he was abandoned at the orphanage and then adopted and then came to the United States. And he talks about the fact that he didn't learn the English language till he came here and he learned it by small talk and all of that. He does a pretty good job, I thought, but I thought the really important part was not being able to look anybody in the eye and also the fact of, everything relates to what he has been through. But in some respects, that backfired because the state was able to use that in their rebuttal closing, and I thought they did this reasonably effectively.
Defense counsel argued that defendant told you yesterday, and he did, that this has a lot to do with everything I've been through and everything I've seen. You've heard no evidence, zero evidence of the defendant and what he saw and what he's been through. You are not.
Burden shifting?
I'll overrule the objection. I'll just remind everybody, there's no obligation or burden on the defense to do anything. You may continue.
The defense has no burden. But when you hear arguments that defy logic, you can reject the arguments by the defense. The defendant doesn't have to prove anything in this case, but he did. He proved everything in this case when he took that stand yesterday, and he said, I was sitting in the car thinking about it before I went into the house. I thought about killing my parents before I went into the house. So again, does the defense have to prove anything? No. Is it my burden? Yes. And I urge you to hold the state to its burden. But you have heard no evidence, absolutely no evidence about what the defendant has seen and what the defendant has been through. And that is not burden shifting. That is simply a fact.
So I'm not much a fan of these rather odd pauses and disconnected stops during the middle of her presentation. Maybe she thinks that's effective, I don't know, but I do think her argument was actually quite good. Yeah, he did prove something. He proved that he knew exactly what he was doing and it was premeditated. I think it's a good argument. I think it's try as hard as he might, the defense is not going to be able to overcome his client's own testimony. And he probably spent hours trying to tell this guy, absolutely don't get up there on the stand and testify. But he did it anyway, because he's the only person who can make that determination, obviously. So we'll now see how the jury comes out. I imagine they may have a verdict before I even get this thing edited and put up on YouTube, but we'll see. Thanks for watching. I appreciate you being here today. If you have the opportunity today, try to do one kind thing to help somebody else. Any kind thing will do. Buy somebody a Coke, get them a cup of coffee. Anything that makes their day better. That would be a way to help make the world a better place. Because after all, isn't that what we're all after? Now, YouTube has a few things that they think you might be interested in, and they're going to be showing you that right up there.